I'd like to call upon Bob Klotz to speak to us about protection of unpaid suppliers. Bob is a partner in the law firm of Klotz Associates and practices mainly in the area of insolvency, commercial litigation, and international law. Bob is a frequent speaker in Canada and abroad on issues of insolvency and is the author of Canadian Bankruptcy Law. He is the past legislative coordinator and current program coordinator of the insolvency section of the CBAO, Ontario section, and if our democratic elections work the way that they're supposed to be rigged, I think he's going to become the vice chairman in June. Bob?
Good afternoon, ladies and gentlemen. Does that carry? I'd like to thank Frank and Aubrey for not including my paper in this morning's materials, ensuring that you'd all be here present this afternoon to guarantee me an audience. Now, this paper was difficult to do because of the changes in Bill C-22 and the continual uncertainty over whether it's going to be passed in this form or in an amended form. After the date of this conference was rescheduled for the second time, I decided to measure the progress of the new act by whether the various C-22 conferences were proceeding as planned or being rescheduled. And whenever I was in some doubt about how the legislation was doing, I'd simply call up the Institute and say, well, is your program going on? Or call up the Law Society and say, are we still proceeding on May 26th? We're here today. That tells me something about whether the act is going to come in this form or similar form. I also vowed, after the second rescheduling, that I would begin my paper only when the date of this conference was clearly confirmed. I did receive a fax confirming today's date with a PS that said, your papers are due today. At that point, I began my paper. However, between that date and today's date, my particular section was substantially amended, and therefore I feel that my procrastination was vindicated. Now, one of the challenges of understanding Bill C-22, as I'm sure you've all no doubt seen, is the necessity of looking first of all at the existing act, then superimposing the first reading version, which you now should have, and finally adding in the latest amendments with their squiggly lines that you've also got in your materials. For the ease of understanding my topic, I've prepared a consolidation of the unpaid supplier protection provisions. That is section 81.1 and 81.2, and you'll find that at E26 in my paper. While I'm at it, I'll tell you what else is there. There is a draft regulation and draft form that I'll briefly touch on if I have time. There's a copy of the analogous Quebec provisions in the Civil Code that give a right of revendication that our new unpaid supplier protection is patterned after. And finally, the comparable US provisions. And again, I'll touch on those, but they're there in your materials for your review. Now, why do suppliers need added protection beyond what they've got in the existing Bankruptcy Act? As I'm sure you all know, suppliers are at the low end of the totem pole in receivership or bankruptcy matters. They are unsecured creditors. They rank behind secured creditors and behind preferred creditors. They often get nothing or a minimal dividend. They're also subject to a particular form of abuse called juicing the trades. How do you juice the trades? You, as the owner of a business who have guaranteed its debt to the bank, discover that the bank is undersecured, therefore you are exposed under your guarantee. What do you do? Under the existing Bankruptcy Act, you order a lot of goods. You wait until you've stockpiled your inventory, and then you file your assignment of bankruptcy or call in the receiver. The bank has first charge on the inventory, which is now huge, so the bank is paid out, your guarantee is no problem, you're no longer undersecured, and it's the creditors that lose, often in a major way. Now, when this is done crudely, it may amount to fraud by the owner of the business, ordering goods when it's clearly known that there's no intention to pay or no possibility of payment. But usually fraud is difficult to prove, and in the ordinary course, this is something that creditors, the suppliers, cannot protect themselves from. So this is a particular form of abuse that suppliers are prey to, and it's something that these new provisions have been designed to reduce, although, as you'll see, they do not eradicate the problem. Special attention has been paid to farmers, the agricultural business, and this is because of the particular nature of their business, and that is they often sell their commodity in one sale at the time of the harvest to one purchaser on terms that they cannot dictate. If after that one sale the purchaser goes bankrupt under current law, the farmer loses the entire year's production. and that as well has been changed to give some protection. Now, the problem in granting suppliers protection is that you're thereby limiting the rights of lenders to inventory. And this is the fundamental flaw, the conceptual flaw of these provisions. Because when lenders' rights to inventory are reduced, they lend less. There'll be a contraction of credit, and I'll discuss this in a little bit more depth as to how that contraction will work. It's this effect, the contraction of credit, which has made the provision so controversial. The vast majority of submissions to the committee believe that we are shooting ourselves in the foot by introducing these unpaid supplier protection provisions. Now, it was interesting to me when I went through the various submissions that Dave Stewart was kind enough to forward to me to see who was in favor of these provisions and who opposed. And there weren't too many people who favored the provisions. The Canadian Federation of Independent Business, the Canadian Apparel Manufacturers Institute, the Canadian Federation of Agriculture, and lately the Canadian Cattlemen's Association. Who was opposed? Again, this is just for your interest. The Insolvency Institute of Canada, the Bar Association, the Canadian Bankers Association, the Canadian Insolvency Association, the Chamber of Commerce, the Board of Trade, and the Canadian Cooperative Credit Society. Who came down on either side of the line? Well, the Quebec Bar Association and the Mouvement des Caisses Desjardins said that as long as you stay out of our way in Quebec, we don't mind. And as long as you permit provincial rights to overcome or to stay in existence, we don't mind. So there's the Quebec provision. Stay away from us. And they got that in these provisions. There are two kinds of unpaid supplier protection under two separate sections. First of all, Section 81.1 provides a 30-day right of repossession under specified conditions. Secondly, Section 81.2 provides for a 15-day super priority for farmers, fishermen, and aquaculturists. What is an aquaculturist? Someone who cultures aquatic plants and animals. And the reason they're in the Act, I was told this morning, was because the chairman of the committee was an aquaculturist. Helps, I guess. These sections only apply to goods delivered after these sections come into force. Now let me deal with Section 81.1 in more detail. It applies only where a business has gone bankrupt or into receivership. It does not apply to proposals. It does not apply to CCAA applications. It provides that suppliers may repossess goods delivered within 30 days. And there are a number of provisos. First of all, they must present a notice within that 30-day period to the trustee or receiver. And let me discuss that for a moment. I'll take an example. If receivership occurs on June 30th, the goods were delivered on June 3rd. The right of possession, just dealing with the time constraint for a moment, will apply if the demand is delivered to the trustee or receiver before July 3rd, 30 days from the date of delivery, June 3rd, but after a trustee or receiver has been appointed. So the demand must be delivered between June 30th, date of appointment, and July 3rd, 30 days after delivery. An extremely narrow time frame to deliver the demand, because at the time of delivery of the demand, there must be a bankruptcy or receivership. If, for instance, the goods were delivered June 1st and the bankruptcy or receivership June 30th, there would be a one-day period to present the demand. If it's too early, according to the section, you're out of luck. If it's too late, of course, you're absolutely out of luck. Now, this gets exciting when we talk about the delay for receivers and trustees to notify creditors of the receivership or the bankruptcy. And you can just imagine what that 10-day lapse of time will do to these rights. I'll get into that later, and the material deals with that. Now, there are 4 additional requirements superimposed upon this timing requirement. First of all, the goods must, at the time of demand, be in the possession of the purchaser, the trustee, or the receiver. The goods must be identifiable. They must be in the same state as they were when they were delivered, and they must not be subject to sale at arm's length or an agreement to sell at arm's length. And arm's length is defined in the Bankruptcy Act. If all the requirements are met, the right of repossession ranks above all other claims except for a purchaser in good faith for value without notice. The trustee has the option, when presented with a demand, to either pay off the remainder that's owing on the goods and keep them, or to permit their return. If part payment has been made on the goods, the supplier has the election of either refunding the part payment and taking the goods back, or simply repossessing a proportionate amount of the goods. If, within the 30 days, the trustee or receiver sells the goods at arm's length before receiving the notice, the protection is lost. It doesn't extend to proceeds. And it might interest you to note that the bar in Quebec, so I'm told in a colloquial sense, is quite experienced at advising their clients how to immediately commingle goods and dispose of them very quickly. There will be a premium on quick sales as long as they're at arm's length, because that will beat out the unpaid suppliers. If the trustee or receiver decides to admit the claim, the goods must be retrieved within 10 days or the protection is lost, and that time period can be extended on consent. But that is that's a period that will give some unwary suppliers problems. That's Section 81.1, the right of repossession. Some 2 weeks ago, Section 81.2 was introduced with very little fanfare and quite abruptly. There was a submission made by the Canadian Cattlemen's Association that essentially said, look, what about the farmers and the fishermen? As soon as they deliver their goods, they're unidentifiable. And as soon as they deliver, let's say, their tomatoes, they're processed into tomato soup or tomato paste or God knows what. So they get no protection from this provision because of the identifiability requirement. As a result, they succeeded in having Section 81.2 introduced. And I might add that there's a comparable provision in the U.S. Bankruptcy Code. And the submission made by the Cattlemen's Association is peppered with the buzzword international competitiveness, which carries great sway these days. They carried the day, and that proposal was introduced the same week, unbeknownst to many of us. It applies to farmers who have sold products of agriculture, fishermen who have sold products of the sea, and aquaculturists who have sold products of aquaculture. It protects debts for products delivered within 15 days before the bankruptcy or receivership, provided a proof of claim is filed within 30 days after that date. I should say after the bankruptcy or receivership. Let me give another example of dates. If the receivership is June 30th, and the goods were delivered June 16th, 14 days earlier, the supplier has a period of 30 days from the receivership, that is until July 30th, to file its proof of claim. It's a much more belated time period, much less likely to have slips in that period. It's also a matter of filing a proof of claim instead of presenting a demand. Filing doesn't require personal service, at least as far as I can tell, whereas presenting a demand, in my opinion, as prudent practice, requires personal service on the trustee. Mail is simply not sufficient, although the U.S. legislation and the cases do permit it there. What other requirements? If the products are also identifiable and the provisos of the previous section, 81.1, are met, then the right of possession can be exercised. Otherwise, the producer of these goods is entitled to a first charge above all other charges against inventory, and that's inventory generally, not simply the inventory that we're dealing with here. A first charge against all inventory in the possession of the purchaser on the date of the bankruptcy or receivership. The trustee or receiver who takes possession or disposes of this inventory is liable to the supplier to the extent of the net proceeds. So the trustee can deduct, or the receiver can deduct, the cost of realization, but it's a liability to the extent of the net proceeds. The priority does not extend to accounts receivable of inventory, although apparently there is great political pressure being brought on the government now to extend 81.2 to apply to proceeds of inventory, and that will certainly enrage the banks more than they have been to date. I'm told through the grapevine that it's unlikely that this section will be further amended, but who knows? That's the overview of those two provisions. Let me now deal with some specific problems of the bill. First of all, the economic impact. As I've mentioned before, both sections reduce the pool of inventory that's available as collateral for secured lending. And this will result in an inevitable contraction of bank lending because of the recalculation of margins. I don't know what the usual margin is for any particular industry, but each industry has them, a margin that's applied to inventory to calculate the level of bank lending. As inventory is recalculated downward, that margin will result in less credit. How much less? Well, it's difficult to calculate the extent of the Section 81.1 priority because no one knows in advance how much is still identifiable at a given date, how much is still in the same state, how quickly it leaves the possession of the purchaser. So it's difficult for a bank to know in advance to what extent to lower the margins. Banks, being conservative by nature, they may tend to lower margins by the amount equivalent to 30 days of inventory. That would be the outer limit of the Section 81.1 priority. And that's too much. But that's probably what's going to happen. Lenders will adopt this conservative estimate and decrease the credit lines as soon as this act comes into force. Now think of seasonal industries, Christmas stores. The vast majority of their inventories will be under 30 days or close to that 30-day period. So at the very moment, just before Christmas, when they need all of the credit they can to make their Christmas sales, the banks will contract their credit lines by the maximum. So this is going to cause a real squeeze to retailers. I also suggest that there may be preemptive receiverships just before the act comes into force. Because once the act comes into force, inventory is no longer sacrosanct to the bank. So in the weeks before, banks will be taking a very close look at inventory levels, and that's when they may move. They won't have to worry about the aggravations of their receiver dealing with these uncertain provisions and with the loss of their priority. The benefit for suppliers is clearly at the expense of the business community generally, and in particular at the expense of retailers, because this right of repossession only applies to goods sold for business purposes, not for consumer purposes. The retailers have no benefit whatsoever from this unless they retail to other businesses, and even so, their inventory is going to be scattered all over the place. It's not really a great help to them, but they're the ones that are going to feel the squeeze. Now let's deal for a moment with the trustees and receivers. They're going to be incurring added time and expense in identifying these goods once the demands are received, in segregating them once they're identified to prevent them from being resold with the pool of other inventory or other goods. And they may need to solicit the cooperation of management to identify the goods or to prove that they're not identifiable. I have a case right now where our client, in effect, purchased through an agent some machinery, and we didn't know what it looked like. The trustee who took over had no idea what it was, and we had to find someone in management who at that point was not too interested in cooperating to be able to identify the goods. Now, we knew they were identifiable. Everyone knew they were identifiable, but no one could identify them. And that's the kind of problem that we may be looking at that will just hold up the administration of an estate. If you know they're identifiable, you can't identify them, you can't dispose of your inventory until you've resolved that problem. That's the type of concern I think that trustees and receivers have. There's also a cost of uncertainty in assessing these claims. Resolving these claims is heavily dependent on the facts, what goods were shipped, where the serial number is, how they can be differentiated from one another, where they were stored in the plant, that sort of thing. These require affidavits. They can't be decided on a question of law so much as a nitty-gritty determination of facts. And as well, they're poorly amenable to a summary resolution through affidavit evidence. Everything will turn on credibility and on inspections and so on. So although there's a summary procedure that these new sections outline for resolving these problems, it's going to be of limited utility. Let me turn to the effect of these provisions on reorganizations. Now, in the first reading version of the Act, there was no reference made to the proposal proceeding under the new Bill C-22. In other words, a proposal had no effect, did not give rise to repossession rights. Under the amendment that's been approved and that you have in your materials that's been incorporated into the section that I've given you, once again, a reorganization does not give rise to a right of repossession unless it fails. If it fails, the 30-day period is deemed to have been suspended throughout the time that it was in effect. And so suppliers in the 30-day period prior to the reorganization being commenced will be protected provided they comply with these notice provisions. Now, how do you comply? Well, you get your demand ready as soon as the reorganization is filed. If your goods were delivered 29 days before that date, you better make sure that it's presented within 1 day after the reorganization is annulled. Because if you don't, you've lost your 30 days. And my arithmetic may be wrong, it may be the 2 days you have, but you get the point. The demand has to be prepared, and as soon as the reorganization is annulled, you must present it. Now, what goods does it apply to at that date? Well, what is still identifiable, still unsold, still in the same state, and still in the possession of the debtor after the 5 or 6 months that this reorganization has been flying? Well, what will still be on hand will be the damaged goods, the out-of-season goods, the non-selling inventory, and the out-of-size stock. So that is what remains of the unpaid supplier's protection after a failed reorganization. Now, it's something, but it's not worth a heck of a lot. What effect will this have on the practice of reorganizations? Well, you recall the problem of juicing the trades. It has now altered in form. If you want to juice the trades, what you do is you bulk up on inventory, and instead of bringing in a receiver or filing an assignment, you file your reorganization. And until that reorganization is defeated, and you may know it's going to be defeated, but until it's defeated, unpaid supplier's protection is deferred. And you can continue to sell off this inventory and pay off your bank. So there's an inherent flaw in this protection, and that's what we'll see. Now, perhaps that conduct will be fraudulent, and perhaps there'll be devices for controlling the abuse of a reorganization proceeding. But as you all know, there is a prejudice in the courts toward permitting these reorganizations to succeed. Every opportunity, look at Olympia, New York, every opportunity will be given to have one of these things fly. And so it's going to be difficult to get a judge to say this was a fraudulent reorganization attempt. It was doomed from the start, and it was criminal to file it. So what we'll be seeing are preemptive reorganizations. By the same token, the CCAA beats the supplier's protection in both sections, both the right of repossession and the farmers and agriculturalists, because there's no receiver or trustee appointed under the CCAA. So there is no unpaid supplier's protection under CCAA. There is some protection given under 81.2 if a proposal fails, but the section is very badly drafted, and I've outlined in the paper some of the very difficult problems that will result in that event. By the same token, if a bankruptcy petition is filed, the section doesn't answer any of the problems which arise. The relation back doctrine applies so that the bankruptcy will have been deemed to have taken place on the date the petition was filed, which means you have to have your notices in based on that date. But on the other hand, how do you know when the petition was filed? Well, there's no notice requirement for telling creditors about the filing of a petition. There's no way creditors find out, other than perhaps through some of the credit magazines, that a petition's been filed. So there's no way they can meet the 30-day time limitation. What about those creditors who do? What happens to their goods when the petition is ultimately successful 4 months later and their goods have been sold in the meantime? Who's liable for that sale? Can they trace the goods? I mean, these questions aren't resolved at all, and I really don't know how they'll be resolved. Let me talk about the specific requirements of identifiability and same state. The exact wording of the section is, quote, identifiable as the goods delivered by the supplier and not fully paid for. And the other section reads, in the same state as they were on delivery. Now, the Quebec Civil Code uses identical language regarding the same state. The U.S. has slightly different tests. They don't require that it not be altered, but they do require identifiability. The case law in both jurisdictions is germane, although you do have to compare the legislative framework before you apply the cases. There are 3 problems that I've addressed in the paper that will come up. First of all, what happens when you have commingled goods? That is, in one of the examples, aviation fuel. Supplier delivers aviation fuel. It's the only supplier of aviation fuel. There's a delivery within the last 30 days, and it's mixed. Whoa. It's mixed with previously delivered fuel outside the 30-day period. Has that fuel lost its identifiability? Well, the case is cut both ways. Processed goods. Now, there are cases from Quebec dealing with the classic cases, opossum pelts. These pelts get tanned within the 30 days, And are they still in the same state? Well, a Quebec case said yes, as long as they're only superficially altered, they're still in the same state. Well, that's a problem. Appliances which have been hooked up and installed, are they in the same state? In Quebec, yes, and those cases will be persuasive. Cut goods, the fabric is cut but not yet sewn into pants or some odd. One of the Quebec cases say they're in the same state as long as the supplier pays compensation for the value-added labor. Again, that's a problem under the wording of this Act, but if the Quebec approach is adopted for the purpose of national consistency, and it may well be because the wording is the same, then we'll be dealing with those kinds of issues. Finally, accessions, where in one case, the crane is attached to a truck. Is that still identifiable and in the same state? And there is here a line of Canadian cases under the topic of accession of goods, which finds its way into the PPSA, that deals with the degree to which goods become acceded to other goods. And the basic rule is if they're detachable without undue difficulty and they're still identifiable, they do not accede, and therefore one can argue the unpaid supplier's protection still applies if you can detach. Timing issues. When are the goods delivered so as to start the 30 or the 15-day period? There is a definition in the Sale of Goods Act for delivery. It says the voluntary transfer of possession from one person to another, but it doesn't define possession. So you have to look at the definitions of possession, and there are lots. There are some presumptions in the Sale of Goods Act which seem to indicate that possession occurs when the bill of lading exchanges, when the goods are loaded onto the carrier. In other words, possession occurs off in Taiwan when the goods are loaded onto the ship. Of course, if it takes more than 30 days for the goods to travel from there to here, then what benefit are these unpaid supplier provisions? Because during the course of transit, the supplier already has the right of stoppage in transit to, meaning stoppage while the goods are in the carrier. So if delivery starts when the bill of lading changes hands, or when the goods are delivered to the carrier, then that's of little use to suppliers. I've argued in the paper that delivery starts when the supplier gets actual possession of the goods. But that's not what the section says, and that's an argument that's certainly open. Let me get back to the notification period. You've heard, I believe, from Frank about the receiver's obligation to notify creditors of the receivership. That's a 10-day period. The receiver has to do so within 10 days. A trustee has to do so within 5 days. Now, if goods have been delivered, let's say, 20 days before the receivership, what is the receiver going to do? If he sends out his notice on day 21, the unpaid supplier will send in a demand and be entitled to priority. If the receiver defers to day 9, sending out the notice, as he's entitled to do, the mail takes 2 days, and it's certified mail, so it takes 5 days. That brings us up to day 32. The supplier's out of luck. So receivers may defer until day 8 or 9 or 10, sending out the notice, so as, for practical purposes, to reduce the protection from 30 down to 20. And by sending by certified mail, they may reduce it down to 15. That's the problem. What if the receiver doesn't send notice at all? After all, the receiver's got an obligation to check as to the identity of all the creditors. Now, the list is never complete. The debtor doesn't cooperate. The records are in a state of disarray. What if the receiver doesn't send out any notice at all? Well, the protective section for receivers protects the receiver from liability for sending out notices, but does not, by my reading, protect the receiver from not sending out notices. So it seems to me there's some vulnerability there if a supplier loses its protection because the receiver or trustee has not sent out the notice. And this will be liability for negligence on the receiver or the trustee for not taking steps knowing that suppliers have their protection that's exposed. One last point while I cut my talk short, and that is the concept of a blind demand. Because of this timing problem, not knowing for sure when the company has gone into receivership and having that 10 or 12 or 15-day period of just not knowing, suppliers might consider on day 27 or so sending a blind demand for repossession. That is, we hereby demand repossession of our goods. That way, if there has been a receivership or bankruptcy within the last 10 days, they'll catch it. If there hasn't, they can't lose. There are some problems because the regulations seem to require, at least as they're currently drafted, and that's not a final version, Dave Stewart tells me, The regulations seem to require the name of the receiver or trustee and perhaps the date of the receivership or bankruptcy. And if you send a blind demand, you can't know those things. But that is certainly something that I'd recommend to my clients, to send a blind demand, and we'll see if the courts permit it, given that it doesn't contain any of the details. Thank you very much.
I think it's going to be a good business development practice to put right in your invoice. You know, net 30 days and we're demanding the stuff back. I want to thank Bob. I'm impressed. I was worried about this talk because I read the sections and figured, how the hell can anybody talk for more than 3 minutes on this? And you've done a good job. I also think back in the days when my parents forced me to go to Hebrew school and I was studying Talmud, and they used to talk about red cows and spoiled oil and wheat with rats eating. You know, what relevance does this have to me? And now Bob's talking about tanned raccoon pelts or something, and maybe we should dig out the old books. I'd like to call upon the next speaker, John C. Spencer. And I have to admit that I don't know John. I just met him a second ago, but I think I have a sense of the man, because I've looked at everybody else's bios, and everybody touts themselves and tries to get counsel work, but John has given us the essentials. Counsel, Insolvency Group, Commercial and Real Estate Property Section, Toronto Regional Office, Department of Justice, B.A. Alberta 1972, M.A. John Hopkins 1974, LLB Toronto 1985, called to the Bar of Ontario 1987. We know that this is not going to be somebody who's going to snow us. He's going to tell us the bare essential facts. I call upon John.
Thank you, Aubrey. Now, I'm an employee of the Department of Justice, and I did prepare a paper, and I sent it up to Ottawa, and I haven't heard anything back from Ottawa on that paper yet. I hope that as a result of giving this talk, I don't hear something back from Ottawa, and I cease to be an employee of the Department of Justice, because the opinions are my own. I haven't been involved in drafting the legislation, and I haven't been involved in any of the committee stuff. I am here to give you my view of Crown priorities and how I will use them in my practice in the insolvency section. Now, I'm going to deal with my topic under 5 headings. First, the abrogation of certain preferential rights. Secondly, secured claims of the Crown. Third, deemed trusts in the property of the bankrupt. Fourth, the enhanced requirement to pay. And finally, the statutory stays of proceedings. But before I turn to the subject of statutory preferences, I'd like to try to establish some sort of context from which to view the changes proposed by C-22. In 1970, the Tassé Committee called for the abolition of Crown priorities in bankruptcy. It voiced concern over the increasing use of unregistered statutory charges and liens to enforce statutory payment obligations. It recommended the compulsory registration by the Crown of all such charges and liens, presumably in order to prevent ambushes of other creditors. The Tassé Committee also had misgivings concerning the Crown's use of statutory trusts to enforce payment obligations. The committee could accept the use of a statutory trust to protect the interests of the Crown, but insisted that the trust should be impressed only on cash in the hands of the debtor. It maintained that the Crown should not be allowed to trace its statutory trust funds into other assets of the debtor. By the time the Coulter Committee submitted its report in 1986, the emphasis in Crown collections had changed a good deal. In a world of comprehensive security agreements, the federal government had come to rely less and less on its common law right of prior payment among debts of equal degree and its statutory preferences under the Bankruptcy Act. It had increased the scope of its deemed trust provisions. What had begun as an enforcement tool for the collection of Canada Pension Plan contributions and unemployment insurance premiums took on a much more important role when it was adopted for use in collecting unremitted source deductions and amounts withheld for non-resident tax under the Income Tax Act. So long as the trusts were used only to enforce collection of CPP and UI payments, the amounts subject to deemed trust provisions were comparatively insignificant. Adoption of the statutory trust to protect source deductions and non-resident withholding tax made it the guardian of the major portion of income tax revenue. By the time of the Coulter Report, the provincial crown was also finding the statutory trust to be an extremely interesting or useful device for ensuring collection of statutory payment obligations. Because by 1986, we had Burgo, and the courts were demonstrating an increased reluctance to allow provincial crown liens and charges to elevate such crown claims in bankruptcy from preferred to secured status. I'll talk about that later. It would be another few years before the courts would also cast an unsympathetic eye on provincial deemed trusts in Samson-Belair. The Coulter Committee didn't distinguish between the federal and provincial crown with respect to deemed trusts. It recommended the abolition of all statutory trusts. It also urged the abolition of all statutory liens and charges purporting to give priority by way of security for any debt not contractually incurred. With the exception of contractually created priorities, all claims of the Crown were to rank in the same priority as unsecured creditors. Such was the view of the Coulter Committee in 1986. Now, Bill C-22 does not abrogate all non-contractual rights by the Crown to rank in priority to ordinary unsecured creditors. It does impose restrictions on the statutory preferences of the Crown, which appear in paragraphs 136, 1H and J of the present Bankruptcy Act. Those restrictions ultimately will eliminate the advantage generally held by the Crown over ordinary unsecured creditors on the distribution of proceeds realized from the property of a bankrupt. Bill C-22 also introduces a new provision declaring, and I quote, "All provable claims, including secured ones, of Her Majesty and Right of Canada or a province to rank as unsecured claims," unquote. But specific exceptions to this general rule significantly decrease its scope and effect, and we'll look at that. Bill C-22 certainly does not extinguish the powers of all statutory trusts to encroach on funds otherwise available to satisfy claims provable in bankruptcy. But the bill does contain restrictions which may inhibit any further expansion of the role played by statutory trusts in Crown collections. The bill also establishes a framework for formal proposals which accommodates the needs of both statutory trust claims and effective reorganizations. On the one hand, no proposal will receive court approval unless it provides for payment in full to the Crown within a 6-month period of deemed trust monies and related employer contributions. On the other hand, the collection remedies normally available to the Crown are made subject to a stay during the period when the proposal is being prepared and put into effect. Now, how much will the changes in Bill C-22 affect future Crown collection activities? I think that may depend on how important the statutory preferences have continued to be during the statutory trust era of Crown collections. The general preferential rights of the Crown certainly will disappear. Whether the Crown or ordinary unsecured creditors will notice the disappearance of these preferences remains to be seen. Now, I'll turn to my first heading, which is the preferential rights. And they're familiar to us. It's subsection 136(1) of the present Act, and that is going to be continued over with some modifications into the new Act. And it catalogs, first of all, it states that that scheme of distribution there is subject to the rights of secured creditors, and of course it's also subject to the rights which exempt property from the bankruptcy process. For example, under Section 67 of the present Act, property held by the bankrupt in trust for any other person is excluded from what is defined to be the property of a bankrupt divisible among his creditors. So this scheme of preferences has been created to regulate only the distribution of proceeds realized from the property of bankrupt. There are 10 classes of preference there right now, and the first 9 classes of statutory preference are defined by the subject matter of the claims falling within each class. And each such class ranks in priority to succeeding classes, and many of the classes contain internal restrictions limiting the extent to which a claimant can rely on that preference. Where more than one claimant within a given class is contemplated, a rateable distribution among claimants within the class is stipulated. And the 10th class, different from the other 9, is a residual or general class for all Crown claims, not specifically mentioned in the first 9 classes of preferential rights. This 10th class of preference may be regarded as an importation into the present Act of one of the so-called royal prerogatives, where debts of equal degree are owed by a debtor to the Crown at common law and to other creditors. The debt to the Crown must be paid in full before competing creditors are entitled to receive payment. This principle is usually called the royal prerogative of prior payment among debts of equal degree. Section 216 of the present Act, and it'll be section 4.1 of the new legislation, expressly provides that the federal and provincial Crown will be bound by the statute. In binding the Crown, the Act overrules the usual presumption of Crown immunity to statute law. The rights and prerogatives of the Crown are made subject to the provisions of the Act. It follows that the royal prerogative of prior payment among debts of equal degree does not apply where distributions of proceeds are made under the authority of the Act. So by including that 10th class of preference, the present Act creates a statutory equivalent to the royal prerogative of prior payment. It elevates the Crown just above the rank of ordinary unsecured creditors for unsecured Crown claims, which fall outside the first 9 classes of statutory preference. It has another function, and the case law has shown that. It also regulates priority of payment among the many different types of federal and provincial Crown claim to which it applies. Proceeds to this 10th class of preferred creditor are to be distributed, and I quote, ratably, notwithstanding any statutory preference to the contrary. So for purposes of a distribution of proceeds made under the present Act, and the way it has been up till now, this preferential right overrides preferences given to particular Crown claims by other statutes, from the provincial legislation and so on. Again, re Bourgault. Now, the other specifically Crown type of preference is the 8th class of preferential right under Section 136. And it has been of more concern to the provinces than to the federal government in recent years. That's claims arising from, and I'm quoting, all indebtedness of the bankrupt under any Workmen's Compensation Act, under any Unemployment Insurance Act, under any provision of the Income Tax Act, creating an obligation to pay to Her Majesty amounts that have been deducted or withheld. They're to be paid ratably out of proceeds realized from the property of a bankrupt. Well, the Alberta Workers' Compensation Act and Deloitte Haskins and Sells case ran into problems there when the charge created under the provincial legislation came up against the Bankruptcy Act, and the government found out, the provincial government found out it was merely a preferred creditor at the 8th level of preference rather than a secured creditor under its legislation. And the rule has been is that where bankruptcy proceedings have been initiated, the provincial authorities are stuck with going within the bankruptcy administration. They are not going to be secured creditors, and their charge and liens would not do anything. Now, the abolition of that section, that preference, may do interesting things for preferred secured claims. You've still got the definition of secured creditor at the beginning of the Act, and certainly some of the case law talks about that. But maybe this is one of the results of this is going to be that provincial charges, liens, privileges, whatever, in their legislation no longer are going to get caught by this preferred thing under 136 of the Act. You're going to end up in a situation where they're back with the secureds and outside the scheme. Now, what happens with C-22? Clause 111 sub 2 repeals paragraphs H and J of the present Act. What it substitutes for them is very similar language, but it says those preferences only will apply to bankruptcy proceedings commenced prior to a certain prescribed date, which I presume will come in the regulations. And those, so for any bankruptcies occurring after that prescribed date, the trustee can in effect just ignore H and J. So you lose that one for workers' comp stuff, and you also lose J, the general right of the Crown, which just puts the Crown above the ordinary unsecureds. So now the amendments in Clause 111 sub 2 won't deprive the Crown of all preferential rights under subsection 136(1) of the Bankruptcy Act. Where the Crown happens to be the landlord of the bankrupt or the first executing creditor, it presumably could rely on paragraphs 136(1)(f) and G to claim a statutory preference. But those preferences are available to all creditors of a bankrupt and are not an exclusive right of the Crown. Moreover, the advantage they confer on the preferred creditor is restricted and usually of little consequence. Now, whether the Crown will recover significantly less and ordinary secured creditors will receive correspondingly more as a result of the disappearance of the residual preference in subparagraph, or in paragraph J, remains to be seen. We've got to recall that the preference ranks behind all trust claims and exemptions, all secured claims, and 9 classes of preferred claim. For many estates, little or nothing would remain available to be distributed to the last class of preferred creditor. Having the Crown share this little or nothing with ordinary secured creditors in a rateable distribution may not significantly improve the lot of those creditors. I guess it's just how much is going to trickle down when you have the stuff at the top. Now, my second topic is secured claims of the Crown. I've already quoted you what is going to be a new subsection 86.1 found in clause 96.1 of Bill C-22, which establishes the presumption that all provable Crown claims will rank as unsecured claims. Again, the actual language of the subsection is, in relation to a bankruptcy or proposal, all provable claims, including secured ones, of Her Majesty and right of Canada or of a province, rank as unsecured claims subject to subsections 2 or 3, and they're the things that matter here. Subsection 86.2 reverses the effect of the general rule by excluding 2 specific classes of provable claims from the effect of that rule. Now, 86.2 says, subsection 86.1 does not apply, A, to claims that are secured by a security or privilege of a kind that can be obtained by persons other than Her Majesty, so it's a generally available security, pursuant to any law or pursuant to provisions of federal or provincial legislation where those provisions do not have as their sole or principal purpose the establishment of a means of securing claims of Her Majesty. So the general law, general statutory powers, anybody can have it. If the Crown uses it, goes that way, the Crown also gets priority. By the way, the version of C-22 I am quoting to you is the one. I have modified the C-22 paper, and I'm quoting it in the squiggly version, I think it was called. So there have been some changes. That particular section, I think it said pursuant to any rule of law. Now it's pursuant to any law. There are some more significant changes later in my paper. The second half of this, the second exception to the Crown security being level with all ordinary unsecureds, deals with special kinds of Crown securities, privileges, the sort of thing I was talking about before, the provincial legislation that has tried to create a security to protect workers' comp claims and things like that. That section has a special registration scheme, in a sense following the Tassé Committee and so on, and we will talk about that. Under 86.2a first, the general one I mentioned before that anyone can have, the Crown can prove secured claims in a bankruptcy or under a proposal. Its security must be of such a nature that other creditors of the debtor can obtain similar security from the debtor. Now, for example, Section 220 sub 4 of the Income Tax Act authorizes the Minister of National Revenue to take security for the payment of a debt, and the actual language is, the minister may, if he considers it advisable in a particular case, accept security for payment of any amount that is or may become payable under the Income Tax Act. Now, this provision does not create any new form of security. It merely authorizes the minister to accept such security as debtors generally can offer to their creditors. Security taken by the Minister of National Revenue under this subsection presumably would fall within the 86.2a paragraph of the amended Act. And therefore you would have proper priorities on a bankruptcy and so on. Now, paragraph 86.2b, dealing with statutory Crown securities, addresses the issue when the statutory security created solely or principally to secure a Crown claim will be provable as a secured claim under the amended Act. The provision refers to a new subsection 87.1 for the validity of such security and to a new subsection 87.2 for restrictions imposed on its enforceability. Such security will have no validity in relation to a bankruptcy or a proposal unless it already has been registered pursuant to a prescribed system of registration at the time the bankruptcy or proposal process is initiated. Registration of the statutory Crown security prior to the start of a bankruptcy or proposal proceeding validates the security, but does not ensure that the debt owed to the Crown has been fully secured. Only amounts owing at the date of registration and subsequent interest accruals are secured by such a security. Moreover, this type of security is subordinated to all other security that has been properly perfected on the date when the statutory Crown security is registered. I think a final word should be mentioned regarding Clause 96(2) of Bill C-22. That clause provides for the future repeal of Sections 86 and 7 that I've just been talking about under the amended Act. And they are going to kick in new Sections 86, 87, and 88 to govern the ranking of security after proclamation of the so-called super priority provisions under the Income Tax Act, the Unemployment Insurance Act, and the Canada Pension Plan. Now, these super priority provisions may have been repealed already. They're certainly up for repeal. The draft technical papers are out and so on. So I presume that this section of this Act is going to drop with that when the Income Tax Act and other Act amendments are going in. Third topic is the property of the bankrupt and deemed trusts. Now, persons with claims provable in a bankruptcy proceeding, whether those claims are secured, unsecured, or preferred claims, all look to the property of the bankrupt for satisfaction. A different situation obtains for trust claimants. Section 67 of the present Act expressly excludes from the property of a bankrupt divisible among his creditors all property held in trust for any other person. At first blush, the distinction between bankruptcy claims and trust claims would appear to be quite simple. Provable bankruptcy claims are satisfied out of the property of the bankrupt, while trust claims are satisfied out of the property of the trust claimant. But distinguishing trust property from the property of the bankrupt has become an increasingly difficult task in the era of statutory trusts. Because statutory trust relationships provide the basis for some of the most important claims asserted by the Crown in insolvency proceedings, such relationships require special attention when we're examining the changes to Crown priorities under C-22. Statutory trusts usually occur in situations where a person is obliged to act for the Crown by withholding or deducting for subsequent remittance to the Crown a certain portion of monies otherwise payable to another person. The amounts withheld or deducted by a payer from amounts otherwise payable to a payee are remitted to the Crown on account of the obligations of the payee. The classic situations arise under the Income Tax Act and related statutes. Payers, such as employers, must deduct from the remuneration paid to their employees the amounts required to satisfy the obligations of their employees to pay personal income tax, unemployment, insurance premiums, and Canada Pension Plan contributions to the Crown. Similarly, persons paying royalties or other taxable revenues to non-resident payees must withhold a percentage of all such payments on account of the income tax obligations of the non-resident payees. The amounts withheld or deducted must be remitted to the Crown by the payer in order to satisfy the obligations of the payee. Now, the Crown relies on statutory trust mechanisms to enforce the remittance of amounts deducted or withheld on its behalf. For example, 227 sub 4 of the Income Tax Act states that, and I quote, "Every person who deducts or withholds any amount under the Income Tax Act shall be deemed to hold the amount so deducted or withheld in trust for Her Majesty," unquote. The amounts deducted or withheld belong to the payee, not the payer. These amounts remain under the control of the payer for the sole purpose of satisfying the obligations of the payee to the Crown. Where such funds are identifiable in the hands of the payer, they should satisfy the three certainties of trust law and thus would be regarded as trust funds even without the deeming provision. The enforcement problem for the Crown arises when the funds deducted or withheld by a payer from a payee cannot be identified and distinguished from the payer's own property. The payer may not have segregated the funds to be remitted to the Crown from other funds on hand and indeed may even have misappropriated the unremitted amounts. With no identifiable subject matter to support the trust relationship cannot exist unless certainty of subject matter can be reestablished by statutory intervention. Subsection 227(5) of the Income Tax Act contains a well-known deeming provision which establishes the certainty of the subject to the trust in the event of any liquidation, assignment, receivership, or bankruptcy of the payer. It also overrides the provisions of the Bankruptcy Act respecting what constitutes the property of a bankrupt divisible among his creditors. And I'll quote part of it. Notwithstanding any provision of the Bankruptcy Act, and this little provision is going to be changed because it's going to be the Bankruptcy and Insolvency Act, I think. In the event of any liquidation, assignment, receivership, or bankruptcy of or by a person, an amount characterized in certain ways shall be deemed to be separate from and form no part of the estate in liquidation, assignment, receivership, or bankruptcy, whether or not that amount has in fact been kept separate and apart from the person's own monies or from the assets of the estate. Now, by virtue of this deeming provision, unremitted amounts payable to the Crown can be traced into the property of the bankrupt or insolvent person. To whatever extent proceeds from the realization of the property of the bankrupt must be appropriated to the satisfaction of deemed trust claims, such proceeds stand outside the property of the bankrupt and are not available for distribution to secured, unsecured, and preferred creditors with provable claims. Now, Clause 90 of Bill C-22 addresses the problem of deemed trusts for the Crown by superimposing a set of restrictions on the basic rule laid down in Section 67 of the Act. In the existing legislation, it's the well-known pattern: the property of a bankrupt divisible amongst creditors shall not comprise property held by the bankrupt in trust for any other person. We're going to get that's now going to be section or part of subsection 67(1), comes over into the new act, and we're going to have it followed by a new subsection 67(2), which imposes a general rule restricting deemed trust claims to those supported by actual trust relationships. The property of a bankrupt divisible among his creditors only could be used for the subject of a trust claim where a trust relationship would exist in the absence of the statutory trust provision. Now, that's the general rule, and then it gets qualified. So, subject to subsection 3, which you're getting to in a moment, notwithstanding any provision in federal or provincial legislation that has the effect of deeming property to be held in trust, property of a bankrupt shall not be regarded as held in trust for the purpose of paragraph 1A, the one I've quoted from before, unless it would be so regarded in the absence of that statutory provision. Now, narrow exceptions to this broad restriction are set out in a new subsection 67(3). For the federal Crown, the deemed trust provisions now existing in the Income Tax Act, the Canada Pension Plan, and the Unemployment Insurance Act would be exempt from the restriction imposed by that new subsection 67(2). So, for provincial legislation, exceptions to the rule in subsection 67(2) only would occur where deemed trusts have been enacted to ensure payment of deductions and withholdings of provincial income taxes or of a comprehensive provincial pension plan. So the big mainstream source of revenue for the Crown has survived through this, and it's going to continue on. Some other ones may be trimmed in the bud. Under these proposed amendments to Section 67, all statutory trusts, other than those coming within the 67(3) exception, would be subject to the bankruptcy distribution scheme unless they could establish the three certainties necessary for a non-statutory trust relationship to arise. It appears, and I put these up for two instances: federally enacted GST deemed trusts and possibly provincially enacted construction lien trusts might not survive bankruptcy except where the existence of a non-statutory trust relationship could be established independently. Now, just as the deemed trust mechanism has become very important to the federal Crown and the Minister of National Revenue in particular, in 1987 a new remedy for dealing with those deemed trusts was brought out, and that's what the Crown usually calls the enhanced requirement to pay. I'm probably going to call it the Section 224 1.2 remedy, and it's a very strong version of a garnishment remedy. The enhanced requirement to pay under subsection 224 1.2 of the Income Tax Act, like the other forms of requirement to pay under 224 1 and 224 1.1, is an extrajudicial device available only to the Minister of National Revenue. No judgment, no judicial process or minister's certificate as to the amount payable is needed in order to issue statutory requirements to pay. As soon as the minister assesses the amount payable by a tax debtor, he can prepare and deliver requirements to pay in respect of that amount. These statutory requirements are addressed to persons whom the minister knows or suspects to be liable to make a payment to the tax debtor at any time during the 90-day period following the delivery of the notice. To the extent that requirements to pay operate by allowing the minister to intercept monies payable to a tax debtor by its debtors, they can be regarded as statutory remedies analogous to the garnishment proceedings available to other creditors. But these statutory remedies possess features quite different from those associated with conventional garnishment proceedings. The Section 224 1.2 remedy is the most potent form, but it's also the most limited in its range of application. The section restricts the minister to using it for the collection of amounts assessed under subsection 227.10.1 of the Income Tax Act, or under a similar provision of any provincial statute for the imposition of income taxes where that province has entered into an agreement with the Minister of Finance for the collection of such taxes. Now, the version of C-22 that you have received will refer repeatedly to subsection 227.10.1 in the Crown priority provisions I'm talking about. What happens in the squiggly version is that they just delete that reference. 227.10.1 basically refers to deemed trusts and interest and penalties that are tied in with it. The updated version just pops in 224 1.2, wherever you had seen 227 10.1, and the reason I will explain, it's basically that 224 1.2 reaches beyond deemed trusts and grabs employer contributions to UI and CPP. Anyway, the significance of the 224 1.2 remedy for Bill C-22 lies with the fact that it contains special features designed to protect the interests of the Crown in an insolvency context. Those features can interfere with existing relationships between the debtor and its secured creditors. They also could conflict with the objectives of provisions introduced in C-22 to facilitate reorganizations under a proposal. The Section 224 1.2 remedy permits the minister to intercept monies otherwise payable to a secured creditor of the tax debtor under the terms of a security interest granted to that debtor by the tax debtor, or to that creditor by the tax debtor. The provision also states that on the receipt of the notice by the person liable to make a payment, quote, the amount of those monies that is required by that letter to be paid to the Receiver General shall, notwithstanding any security interest in those monies, become the property of Her Majesty and shall be paid to the Receiver General in priority to any such security interest. Where the Section 224 1.2 remedy comes into conflict with rights and remedies established by any provincial or federal enactment or by any law, its remedial powers will prevail over the conflicting rights and remedies. It's a very potent remedy. Now, in order to be effective, the procedures created by C-22 must be capable of imposing some control, not only over the remedial powers of secured creditors, but also the powers available to the Crown under the Section 224 1.2 remedy. Without some such accommodation of these independent remedial powers, the new provisions relating to proposals could be hampered by contests between secured creditors and the Crown over the very assets that are the subject matter of a proposal. Insofar as Crown collection activities are concerned, C-22 adopts two measures to minimize or prevent any such disruptions. First, it incorporates into the terms of all court-approved proposals an assurance that the Crown will receive payment in full of all amounts recoverable by means of the Section 224 1.2 remedy. Secondly, it creates a series of stay provisions, some of which will restrain the use of the Section 224 1.2 remedy, except where the debtor or other creditors cause the position of the Crown to be worsened during the stay. Now, the assurance of full recovery by the Crown under a proposal is introduced by Clause 81.1 or sub 1 of Bill C-22. That amends the existing Section 60 of the Act, the one which talks about court approval of proposals under the present Bankruptcy Act. And we now have a new subsection 61.1 and 1.2. These provisions deal specifically with the protection of Crown claims when the trustee applies to the court for its approval of a proposal. 61.1 creates a condition in favor of the Crown for inclusion in proposals. It runs, unless Her Majesty consents, no proposal shall be approved by the court that does not provide for the payment in full to Her Majesty in right of Canada or a province within 6 months after court approval of the proposal of all amounts of a kind that could be subject to a demand under subsection 224 1.2 of the Income Tax Act or under any substantially similar provision of provincial legislation, and that were outstanding at the time of the filing of the notice of intention or of the proposal. So you've got to pay it all. If you're going to make a proposal, it's going to have court approval. And it goes further. Subsection 61.2 would carry the protection of Crown claims one stage farther. Even where a debtor's proposal contains an agreement to pay the amounts outstanding at the filing date, the debtor may have failed to meet its current obligations to the Crown during the proposal period. In such circumstances, the Crown may lead evidence of the default, and the Crown can dismiss the application to approve the proposal. And the language is, no proposal shall be approved by the court if, at the time the court hears the application for approval, Her Majesty in right of Canada or a province satisfies the court that the debtor is in default on any remittance of an amount referred to in subsection, the section I've just quoted. Now, so where the debtor has failed to maintain obligations coming due after the appropriate notices were filed, the debtor's agreement to repay in full all pre-filing arrears will not satisfy the court. This concern for maintaining current obligations in good standing also appears in the new provisions dealing with a stay of collection remedies. In those provisions, the stay ends at the moment a debtor defaults in meeting current obligations. Now, I mentioned in passing that the Crown cannot bootstrap itself in using the property rights created under 224 1.2 to get it involved in voting as a secured creditor under the proposals. Of course, it can negotiate things in terms of the 6 months and how much is paid and so on, but unless it has some security giving it property rights other than 224 1.2, it's excluded from the proposal mechanism, and that will be found under a new subsection 54.2 of the Act. Now let me turn briefly to the statutory stays of proceedings. C-22 will repeal the familiar stay provisions contained in section 69 of the existing Act. In place of the present stay of proceedings, C-22 will introduce a cluster of 4 stay provisions. Each provision deals with a specific type of insolvency proceeding. Only the statutory stays pertaining to the filing of a notice of intention and the filing of a proposal need concern us here. Only those 2 types of stays contain provisions to deal with the section 224 1.2 remedy. Amending the present Act to impose a stay over the section 224 1.2 remedy would be a meaningless exercise unless a similar amendment was made to the Income Tax Act. The section 224 1.2 remedy authorizes the Minister of National Revenue to deliver requirements to pay, and I quote, notwithstanding any other provision of the Income Tax Act, the Bankruptcy Act, any other enactment of Canada, any enactment of a province, or any law. Nothing could stop it. Well, the Constitution. A statutory stay of the section 224 1.2 remedy only can be created by amending section 224 1.2 itself. Bill C-22 would do just that. It repeals the opening phrases of the existing subsection 224 1.2 and substitutes a new version which takes into account the expanded scope of the stays created by the new subsections 69 and 69.1 of the amended Act. And it really becomes a mouthful. Notwithstanding any other provision of this Act, the Bankruptcy Insolvency Act, except paragraph 69.1c and 69.11c thereof, end of parenthetical remark, any other enactment of Canada, any enactment of a province, or any law, but subject to paragraphs 69.1c and 69.11c of the Bankruptcy and Insolvency Act, where the minister, and on we go. This amendment to subsection 224 1.2 would make it possible for the new paragraph 69.1c to protect payments of the accounts receivable of an insolvent person from being intercepted by the Crown after the filing of a notice of intention. And if you, 69.1c runs, Her Majesty in right of Canada may not exercise her rights under subsection 224 1.2 of the Income Tax Act in respect of the insolvent person where a variety of things happen. Now, that stay, which appears in each one of those 4 sets of stay provisions, well, excuse me, those 2, the notice of intention and the proposal rights, can end abruptly. Just as the stay is that remedy is stayed automatically upon the filing of a notice of intention or a proposal, so too is it revived without any judicial intervention upon the occurrence of certain events that would tend to erode the position of the Crown. Subsection 69(3) states that the stay does not apply or terminates in respect of the Crown where, one, the insolvent person defaults on payment of any amount that will be subject to a demand under 224(1.2 on current things, and two, where any other creditor is or becomes entitled to realize a security on any property that could be claimed by Her Majesty in exercising her rights under 224(1.2 or under substantially similar provincial legislation. So where the insolvent person fails to remit amounts becoming due after the filing of a notice of intention, he loses the protection of the statutory stay of proceedings. The Crown can resort at once to that remedy and to collect not only the amounts falling due after the filing of the notice, but also any arrears from the pre-notice period, so it can just run right in. In a somewhat different vein, where the secured creditor of the insolvent person is able to use the stay to defeat the Crown's competing claim to the property that the Section 224(1.2 remedy would be available for use against any eligible property, the Crown's remedy is immediately revived when a competing creditor comes in and tries to exercise its remedies. So once again, I think it's not just for the current stuff or that specific asset, it's for the whole thing. The Crown gets to go again. And the underlying principle seems to be that the Section 224(1.2 remedy will be stayed only so long as the Crown's position at the time of filing the notice remains unchanged. Where the situation changes and the Crown's position could deteriorate, the Crown again can look to its remedial powers. There is a provision for lifting the stay. Creditors can go to the court under 69(4). So I wonder if one possibility is that the Crown might be able to ride in on the coattails of a secured creditor doing that as well. Because if the Crown, if another creditor could cause the stay to be lifted, then maybe the Crown, by right of 69(3) or 69(1.3, could automatically have its remedy revived. So, because that other creditor could become, and I quote from the Crown's stay lifting provision, entitled to realize a security on any property that could be claimed by Her Majesty. I think I'm over time. I apologize. I thank you for your attention. Good day.
Thank you very much. I told you it would be to the point and packed full of information. John has supplied us with the latest acronym that I'm sure is going to sweep the nation. The CPPDED, the Crown prerogative for prior payment for debts of equal degree. This is something that's now going to sweep our practice and be used by us all the time. We're going to take a 10-minute break and then have the last two papers.